Hello neighbor, I'm Robert Burns and welcome once again to another edition of Sound Off Louisiana. And I guess to say today was another interesting court day in the Stanford victims trial against the OFI. You may recall that the very first segment that we did, this is segment 6, but that entailed a prospective juror who readily admitted to Judge Johnson that he was a drug dealer, and when Judge Johnson asked for clarification about whether it was legal drugs or illegal, he was honest enough to say illegal drugs. So that had been one, sort of unique circumstance to this trial. Today we had another one. Now bear in mind that the court was not held on Friday, and court did not convene until 1 o'clock. It was actually about 1:30 today, at which time Judge Johnson indicated that one of the jurors had indicated that he or she had tested positive for COVID-19. And that prompted a notification to all the other jurors, and I guess that there was an opportunity to voluntarily test, and that results of that, the results of the test were that there was a second juror who also has tested positive for COVID-19, and Judge Johnson indicated that a third juror, I wrote down, had refused, and he was, and I believe he said he was escorted from the premises after he got into an altercation. So needless to say, this was a day of interest about what the status of the jury is. There were no jurors present for anything today, and at the conclusion of the court proceedings today, Judge Johnson indicated that, look, we're just going to ask the jury to come back in tomorrow morning. We'll try to figure out where we stand. The jury is comprised of 16 members, 12 actives and 4 alternates. So in theory, even if you lost all 3, and even if they were active, you'd still have 1 extra. But now that's on the premise that people are willing to show under these circumstances, because I would imagine that if the jury said, has everybody been tested, they may not be at liberty to divulge that, and some may be reluctant to come. As Judge Johnson said, we'll just have to gauge the way things are tomorrow morning. So rather than just completely not get anything done, the judge did devote this afternoon to having the attorneys, specifically Mr. Phil Price for the plaintiffs and Mr. Dennis for the OFI, argue these points. Well, let me just say this. There has been reference to comparative fault prior to today, but I just haven't reported upon it because there wasn't a whole lot said, and the issue that we're talking about is in the jury interrogatories, placing the various individuals or entities that may be deemed to be at fault on this, and potentially letting the jury assign percentage fault. But when you're talking about having a number of folks who have been in orange jumpsuits beyond just Mr. Stanford, one may conclude that they are largely responsible for what happened here. And let me just say this, Mr. Blunt, Dennis Blunt, as well as Phil Price, they tend to, shall we say, use some non-flattering words for one another as they make these arguments, obviously outside of the jury. And I have read just a few of the pleadings, and they can be equally attacking in the pleadings. Mr. Price indicated on one pleading, he said the filing that was made by OFI, I believe he said, was nothing short of ludicrous. And that may be kind compared to some of the words you will hear today. But at any rate, in fact, Mr. Blunt said that, you know, what Mr. Price is trying to argue here borders on lunacy. That's a quote. And he basically said it's time for us to end this whole dance because it's basically beginning to border on lunacy. Mr. Price is arguing that the pretrial order ought to rule on everything, and he used Mr. Blunt's arguments as silliness, and I'm sorry, that was Mr. Blunt, who's once again going back to Mr. Price's arguments. Mr. Price did indicate that once they've settled in on the itemization of folk that would deem to have comparative fault in this, that he would probably seek a directed verdict on the names that would be deemed to be at fault. And let's say the rest of, well, let me just say this. They got bogged down into arguments involving code of evidence, specifically code of evidence and code of civil procedure. Mr. Price is hanging his hat on Code of Evidence 609, and we're going to give a link for that. And it basically says that you cannot use, or what the element Mr. Price is focusing in on is that you cannot use a criminal conviction to attack the character of someone if that conviction is over 10 years old. And these are all of them, all over 10 years old. You may remember from the first segment that we did that Mr. Blunt talked about a number of people in orange jumpsuits beyond just Allen Stanford, and the substantial prison term that these folks agreed to. Mr. Blunt countered by saying, and he's relying on Code of Evidence 804B3, and we'll give a link for that one and highlight that material. And that one says there is no time limit, because Mr. Blunt argued that, look, there's not going to be one witness up on that stand that I'm attempting to attack the character of. He said basically these people made a statement against interest when they pled guilty to these crimes. And he said as far as the documentation, it would be federal court filings. They are self-authenticating. And he said, so no one can challenge the authenticity of them. And he said, I've got the ideal, the dream world. He said that these folks will have told you, you know the who, you know the how. He said, now the why, you could argue that, well, these are just evil people who wanted to prey on the elderly. But his point was that it doesn't get any better than this, all right? And he is basically saying that, you know, I'm not talking about attacking the character, because they're not going to be live witnesses up there. So he's relying on 804B3, again, that's Code of Evidence, for getting those names of a lot of people in on the jury interrogatories when it's time to go to the jury. I'm going to skip to, because I want to stay on one topic at a time, because we're going to go back, we're going to cover about the two expert witnesses, but when Judge Johnson went to make his ruling on that, he basically said that Mr. Blunt had adequately provided enough detail with the comparative fault basis that he was going to let that rule the day. Those are not his words, but pretty close. Mr. Price then said, well, Judge, I'd like to lodge a formal objection for the record, which Judge Johnson told him he was free to do, and Phil Price indicated that, look, I would have been amenable to amending the pretrial order, but I've been put in a difficult position now because for all I know, there's going to end up being 1,000 people in that's listed on there. And he said, well, let me stop there because I want to shift gears to what was to be Doe-Bear hearings, but so let me flip back because these are all intermingled because that was the two things being argued today. So let's go back to the two expert witnesses that the OFI wants to bring in. One of whom is a gentleman named Mr. Moore. He's attended the entire trial. He is an Alabama securities regulator. And the other one is Carol Van Tassel. I made sure I got the pronunciation, and I was able to get the spelling too, but since this is a video blog, Carol Van Tassel. Now, I had said from the last feature that I wasn't sure what her role was. Well, Mr. Blunt elaborated and made that much clearer. Ms. Van Tassel had been retained by Ralph Janvey. He is the receiver that was in charge of this whole disaster. And Mr. Blunt says that it is Ms. Van Tassel who was able to go in and do the real, forensic analysis on here for the 130 some odd companies that were involved in, they would all Stanford entities to perpetrate this Ponzi scheme. She was the one who was able to dig down and unravel everything. And he pointed out that Mr. Price had originally retained Ms. Van Tassel, but that I can understand why he doesn't want her in here now, because apparently she's unwilling to give any fault at all to the OFI. So what we're talking about is meeting hearsay rules of evidence, and Mr. Price had indicated that, okay, Your Honor, what's going to end up happening is if this thing's all going to be decided on a case-by-case basis on everything that they're going to want to bring in, then we're probably going to end up having 50 sidebars. I wrote that down. He said we'll probably end up having 50 sidebars while the jury is still seated to see this. Mr. Price has continued to push for a Doe-Bear hearing, to which Mr. Blunt has again reiterated what he reiterated before, which was that he is not entitled to any Doe-Bear hearing. The time frame for that has long since passed. And as he was doing the arguing, Mr. Michael Valentino kind of tapped him on the shoulder and showed him what would be Code of Civil Procedure 1425, and I believe it's F2. I didn't write down that. They didn't elaborate the subsections, but I looked it up before doing this video, and we're going to give you that wording as well. But basically it says that if you're going to challenge the admissibility of an expert witness, that needs to be done in order that the trial court can conduct a contradictory hearing no later than 30 days prior to the trial. So I think it would be pretty obvious that there would be no possible way that Mr. Price could fulfill that obligation as required by Code of Civil Procedure 1425, I believe F2, because we're now into the third week of the trial. So how would you possibly get that accomplished? A minimum of 30, the contradictory hearing, a minimum of 30 days prior to trial. This arguing went back and forth, I mean, back and forth like a seesaw. You know, one would sit down, one would rise up, one would sit down, one would rise up, one would sit down, one would rise up. But when everything was all argued, Judge Johnson said that, okay, this is what we're going to do here. This will be a case by case on the hearsay evidence, and I will expect for foundation to be laid, and as the witness testifies, the documents, the foundation would have to be laid, and it's just going to be up to Mr. Price to object, and that's what prompted Mr. Price in making a formal objection on the record, basically saying that the court has a gatekeeping role on this, and what we're going to end up having is 50 sidebars while the jury is still seated. So the bottom line is there will be no Doe-Bear hearing, notwithstanding as hard as Mr. Price pushed for it, because I think that would, the revised statute 1425, I believe F2, seems to be crystal clear on that, and it would be far too late to seek any such Doe-Bear hearing. Should have been done in order that a contradictory hearing was able to be held at least 30 days before trial. So that's going to be a wrap for today. Obviously it's shortened, but as far as the jury situation, like I said, I believe at the outset, Judge Johnson said, look, we're just going to show up tomorrow morning. We're asking the jury to be here, and we'll just have to sort it out from there to see where we're at. I wish I could give you something more definitive, but obviously I would now presume that any thought of this thing going to the jury tomorrow, which will be Tuesday, is certainly out the window. It might even be out the window for Wednesday. So that's it. This was probably the shortest video of all, but you can see why. So that's all there is to report, folks. We'll look to bring you segment 7. Who knows what may be in it, because we have to find out what the situation is with the jury. But we will look to bring you that segment real soon. Thank you so much for your dedication.